Environmental law, we're talking about administrative law principles. And so just to kind of reiterate where we've come from and how this is relevant to the problem number one, okay, is as the official with the U.S. Fish and Wildlife Service, you are going to have to think about what steps you have to go through to comply with various administrative law principles and requirements, and also what potential litigation is out there. I mean, it's, you know, agency officials get sued all the time for decisions they make, possibly decisions that they don't make, and so forth. And so let's think through what we've talked about so far. If the agency, if you say, for example, we're simply not going to do anything about the grasslands or prairie dogs. It's a big issue. We've got too few resources. The problem is difficult to solve. It's not, doesn't fall solely within our agency's jurisdiction, so we're not going to do anything at all. Is there the potential under the APA for a group, say an environmental group, to sue you? Is inaction or non-action something that's actionable under the APA? What do we say on Monday? So some are saying no. Anybody want to say yes? Okay. All right. So it's neither no nor yes. It's in between. What's the correct answer? It is actionable if the agency has a non-discretionary duty to act, right? Okay, its inaction is a basis for bringing a lawsuit to compel agency action that is non-discretionary. It is mandatory for the agency to do. So the environmental group would need to find some sort of mandate in a statute that says the agency must act. Okay? So what happens if if you decide to develop a plan? And the group is unhappy with the plan. Can they sue them? No. The answer is no. They cannot, because
that case we talked about.
right. There's a case. Right? In law school, that's always a good answer, right? There's a case, right? Okay. So the point here is that creation of plans are really about ways of thinking among choices of a variety of sort of broad general principles that the agency might have to consider, right? The agency might have to consider them, but plans in and of themselves are, the choices that the agency makes in the plans are not themselves mandatory, right? So the agency has choices among what they can put in the plan, okay? And so the plan itself is what the courts say, not a discrete agency action. Not a discrete agency action. The plan is just like, we're thinking about, these goals and the strategies that are going to get us towards these goals. In other words, one of the things we're going to get to later is another example of a case where a plan was challenged, and the court basically says it's way too early. That's another way to look at it. Right? There's no discrete, specific action that the agency is taking yet. Okay? They're not cutting down any tree. They're not, fencing off any prairie dog habitat. They're not, they're not doing very specific kinds of things. Okay? So just the plan itself is not the kind of thing that the APA contemplates that there can be a cause of action. Okay? So what happens if the agency, then what you decide in your role in the Fish and Wildlife Service, that to make some specific management decisions regarding prairie dog habitat, right? You're going to make some very specific management decisions regarding prairie dog habitat. Do you think that that might be governed by some specific statutory requirements? Probably so, right? Right? But certainly that would be true if they were endangered. If you are making a decision to not list them as endangered, that might be another specific kind of thing. We'll get into those statutes. Okay, but now just imagine a scenario where now you're, as an agency, you're taking a discrete action, and there is some law to apply. Right? There's a statute, there's some procedures, there's some standards. Okay, so what do you have to do? Do you have a range of choices as an agency? Generally so. Okay. Very rarely does Congress mandate something so precise and specific that it becomes a non-discretionary duty, right? Okay, so generally you're going to have some discretion, but your discretion is bounded. You have to follow the standards. You have to consider the relevant factors. So that is now in this arbitrary and capricious, right? A discrete agency action for which there's some law to follow, and so now the agency's decision is going to be arbitrary and capricious if it relies on factors which Congress had not intended to consider, entirely failed to consider an important part of the problem, offered an explanation for its decision that runs counter to the evidence before the agency, or is so implausible that it could not be attributed to a difference in view or the product of agency expertise. Okay, so the State Farm statement here is a nice summary of the gist of what we see in many of these administrative law cases, okay? And so as an agency official, what you want to do is to be aware of what legal standards you have to apply, what procedures you have to follow. You need to be aware of and make sure that in the process you're considering all of the proper standards and all of the proper evidence that you have before you, and that you are making a thoughtful, reasoned decision. If you do that, it's extremely likely, almost inevitable, that the court will defer to your decision as an agency. So this is in many ways about good decision-making processes rather than the court deciding what the agency must do or cannot do. Okay, so some questions to ask are: what are the steps in the agency decision? How much judicial deference? How much evidence? And generally, when the agency is making a decision, the substantial evidence test is applied. And that's where we left off at the end of last class. That's such relevant evidence as a reasonable person might use to make a reasonable decision. So when we think about evidence, we have, the beyond a reasonable doubt standard, right? Okay, right? Then we have clear and compelling evidence. Then we have preponderance. Right? Preponderance. Yes. And how much is preponderance? 51%. Just a little bit more than 50%, okay? Then we have substantial evidence. Substantial evidence, a scintilla of evidence, just a little tiny bit, and no evidence needed at all. Okay? Okay, and no evidence needed at all generally applies to most legislative decisions. Okay? Congress can adopt legislation that is based on no evidence whatsoever, is based purely on policy choices and value choices and raw politics and interest group politics and what, right? Congress can do that, right? And you're like, if you look at most of what they do, it's pretty clear they have no evidence for what they're doing, right? Okay, so right, so and that's by the way aimed at all of them, both sides, everybody, etc. So no, I mean that's a legislative judgment. The legislature can choose to make policy choices that don't have any evidence behind them at all. Administrative agencies generally have to make a decision based on substantial, I'm sorry, there's a out there, I don't mean, substantial evidence, sorry. Substantial evidence, which is such relevant evidence as a reasonable person might use to make a reasonable decision. So no, it's less than preponderance, even though the word substantial is there. You think, that's pretty, it's less than preponderance, way less than clear and compelling, and barely above scintilla. Right? Okay, so, but it does mean that there has to be evidence, and there has to be a consideration. There has to be an indication in the record that the agency actually considered and weighed the evidence. Okay, so now we're going to turn to something, the sort of next stage is in the process of your decision making about grasslands and prairie dogs, you may need to interpret a statute, right? You may need to make a decision about what the Endangered Species Act means, about what what the statutes governing national wildlife refuges mean, something of that sort. Okay? And so one of the issues is, let's assume for a moment that you make that decision through informal rulemaking, through adoption of a regulation or a rule. And you're now going to decide that grasslands are, the Congress intended grasslands that are home to prairie dogs to get certain protections that just grasslands in general don't get. Okay? And you're going to base that on an interpretation of a statute. And so the standard test is Chevron. Okay? Some of you have encountered Chevron before, Chevron deference. Yes, a couple of you. All right. So this is a typical, this is very standard administrative law stuff. And the main part of it is down here. We're going to jump down, okay, look at 1 and 2, and then we'll come back to 0 in just a moment. Because 1 and 2 is what the Supreme Court originally adopted in Chevron, and then they had this case Meade where they kind of added a preliminary step. So first step, jump down here, is congressional intent clear? If so, the courts will give effect to the clear and unambiguous intent of Congress discerned from the plain language of the statute in its context and overall statutory scheme. Okay? And I mentioned before, the other day, that when we're talking about congressional intent in the language of the statute, we are talking about not only the language on its face, but the language surrounding it, right? The interpretation of the statute as a whole and its overall structure. Okay? So now this is all the statute. We're not talking about legislative history. We're not talking about policy choices. But what we're saying is you don't necessarily just pick, a few words out and interpret only them. You look at the statute as a whole. Okay? And look at what it's trying to do. But if the statute is clear, the agency has to follow that statute. The agency does not have the authority to adopt a regulation or rule or make a decision that is contrary to that. However, statutes are ambiguous. Many statutes are ambiguous. Why? Why are statutes ambiguous?
Is this because it could be more widely applicable and not super narrow to get rid of a very specific thing, like it needs to be specific to a point to get rid of a more generalized problem.
Okay, problems are more generalized, you need breadth of approach, yeah?
Don't they want the agencies to fill in the details of what to do?
They want the agencies to fill in the details. It's a whole system, right? Congress adopts a set of general rules, general principles, general standards, and then they want the agency to fill in the details, right? Okay, right? So that's a part of it. And can you just imagine Congress sitting there trying to decide exactly how many parts per million of 475 different chemicals humans should be exposed to, right? You should understand, I mean, think about that. Think about how little Congress can get done anyway, right? And that level of technical complexity that deals with human health and with scientific evidence, of course, right? They're gonna leave that to the agency. So that gives you a feel for environmental law, some of the kinds of things that agencies do that just aren't gonna be done by Congress. What else? Many of you are not nearly cynical enough. I will make you more cynical by the end of the class. We've already talked about politics once, but we'll keep talking about it. So
I think you might have already mentioned it earlier, but politicians intentionally leave things ambiguous so that if it ever comes back, they can't be blamed for it.
Okay, they don't want to be blamed. Okay, and just think a little bit further about that. That's exactly right. But let's push on a little bit when you take it down the next step, right? They want to promise everything to everybody, right? Everything. I mean, lots of policy choices involve trade-offs. But if you choose A over B, the people who want B are going to be upset with you, right? And so if you're Congress, you want to make as many interest groups as happy as possible by adopting something that says, that promises something that's really either an impossibility or that leaves the hard choices to somebody else, right? And in many cases, it's the agency. Okay, so we're going to have clean air, clean water, lots of abundant biodiversity. Everybody's going to have lots of private property rights. It's not going to cost anything, right? I mean, at some point, you're like, okay, that's just not all possible, right? And so, but that is what Congress does. So Congress will intentionally make a statute ambiguous. Okay? There's some other reasons, but let's talk a little bit about that. How do you think the courts feel about Congress leaving statutes ambiguous?
Busy.
What was that? So I heard somebody somewhere.
A little frustrated because it adds to their decision making.
That makes them for more work. Clogs up the courts.
That's exactly what I was thinking.
Yep. So clogs up the courts. What else? Okay. Think more structurally. Okay. And honestly, I mean, so every branch of government thinks structurally to some degree. If you think that at any point in time, the President of the United States, whoever they are, is not thinking about how they can expand and solidify their power, you are mistaken. Okay, there is no president that we've ever had except maybe when they get get sick or they've been shot and they're on their deathbed, maybe they quit thinking about it then. The rest of the time, every president throughout all of history has thought about exactly that. If you are president, you want big executive power. Doesn't matter who you are, right? I mean, that's what presidents do. Congress. Okay, has there ever been a Congress that has not jealously guarded its Article 1 power? I mean, now it might not be effective at it, right? But every Congress is like, this is our responsibility, right? Okay, so, but Article 3, the judiciary, okay, they are more kind of, they're the gatekeepers not only of the law, but the process, okay? And they are overseeing this whole sort of, balance of powers among the three branches. And so they think about this a whole lot, okay? And what they think about in these kind of situations is Congress is punting on its Article 1 duties. Congress is supposed to legislate, they're supposed to make these policy choices, and instead, because they can't seem to get it done, or they want to, kind of satisfy everybody, or whatever it happens to be, they're purposefully adopting vague, ambiguous statutes, and then leaving it up to the agencies, and then when there's litigation, the courts to sort it out. Okay? So and there are different approaches to how judges deal with this. Some judges feel very comfortable deferring to agencies, others do not. Some judges feel that the courts should be more involved in interpreting the statutes than the agencies, or not. Some don't. But in my experience with federal judges, that maybe not all of them, but most of them, regardless of who they were appointed by, have some degree of frustration with the fact that Congress does this. Okay? So however, it's a little bit more mixed and nuanced than that. They also, as judges, understand that there's a certain inevitability to this, and it's not just political. Okay? So, ambiguous language is an inherent part of language. Right? Law involves language. How much time have you spent in law school all debating and disagreeing and discussing what words mean? Right? You do that a lot. Right? Some of you are looking at me like, am I in law school? I didn't know that. Okay. So no, you're looking at me blankly, but right? But that's a part of what we do in law, right? There's litigation over it, whether it's a contract or whatever it happens to be. What language is inherently ambiguous, okay? And you can embrace that without necessarily embracing all that sort of postmodernism, deconstructionist stuff. It does not necessarily mean that there can be no agreed upon language. We can there's a whole theory out there. The philosopher is Habermas, who sort of says, well, even if language has subjective meaning, we also have shared common meaning. Okay, so you don't have to go down the road of saying there's no meaning to anything to understand that language is inherently subjective, right? Okay? And if language is inherently subjective, just think about how much more so when you're talking about the environment and these various duties and requirements and obligations that Congress is creating. I think maybe Pierce mentioned, or Olivia, I forget who, but basically that there are lots of very specific kinds of situations that are going to come up that no legislature could ever anticipate in that level of detail, right? Okay, so there's another part of this. There's part of this is this politics, and the system or the institutions aren't functioning as well as they should. And there's another part of the institutions necessarily have to function this way because of the way law works, right? Okay, so law and the environment. So anyway, so that's where we come at these issues. And so if the statute is silent or ambiguous, then we go to step number 2. The courts will defer to the agency's reasonable interpretation of the statute. Okay? So as long as the as long as the agency has engaged in a reasonable interpretation of the statute, the court will defer to that if the statute is ambiguous or silent. And so they ask, is the agency's construction of the statute reasonable and permissible, even though alternative interpretations might also be reasonable or permissible? And the theory behind this is twofold. A, the Congress intends for the agency to interpret the statute. Okay? The Congress has adopted these statutes, but they've also created the authority for agencies to implement the statute, and so they intend for the agencies to interpret the statute. And secondly, the theory behind this is that especially in something complex and technical like environmental law, the agency is expert, especially in comparison to the courts. Judges are legal generalists. Agencies have technical expertise. They have our subject matter expertise, and so they get to interpret it. Okay? So that's step number 2. Anybody ever been two-stepping? None of you will admit it either. But anyway, so great fun. I have been two-stepping with federal judges who apply. I mean, so it's just, yeah, so anyway. But actually that is true. All right, so then Chevron kind of existed for a while, and then of course, as you know, the Supreme Court does not. Does not leave things alone. As we kind of go along, we figure out, okay, wait, we need more law. And so they added what has now been step 0, okay, which is, has Congress apparently delegated authority to the agency to make rules carrying the force of law, and was the agency's statutory interpretation promulgated in exercise of that authority? If no to either of these, then no deference to the agency's interpretation. Okay? So this got into the situation where it looked like either, it looked like primarily, one of two things. One is either the agency is adopting broad policies rather than specific rules to implement specific statutory provisions. Okay, so where the agency looks like it's engaging more in broad policy making, that is going to be beyond its delegated authority. Okay. The other problem is when the agency is adopting interpretations that, yes, they might be reasonable based on what Congress has said in the statute, whether the words themselves, but they look like they're taking the statute pretty close to the edge of what is constitutional. What's constitutional, okay? So later on in this semester, we're going to look at wetlands and so forth, and one of the authority of the federal government to regulate wetlands has to do with its authority over navigable waters, which is connected in some way to the Commerce Clause, to interstate commerce. Okay? And in one particular case, the Supreme Court says the agency's interpretation is not what Congress intended in the Clean Water Act. And if that's what Congress intended, it raises some serious constitutional issues about whether Congress is exceeding the scope of its authority under the Constitution, under the Commerce Clause. And surely Congress didn't want that, so no, the agency doesn't have interpretation, or doesn't have authority. So that's step 0. Okay? So that's how that works. If that's seeming overwhelming, I've got a little bit of help for you in a bit here. All right. So then, of course, we keep going beyond where we are, beyond Chevron and need. What about non-law rules and policies? Okay, so what happens if the agency does not have lawmaking authority for the particular question or issues? It's adopting broad policies and standards, using its expertise, and the court has said in Skidmore, so this is Skidmore deference, okay, so we have Chevron deference, we have Skidmore deference. We have that the policies and standards adopted by the agency with its expertise through informal procedures are entitled to respect. Okay, you gotta love the Supreme Court, right? Like what, entitled to respect? Okay, what does that mean? But it means basically less deference than Chevron, but a little bit of deference, right? It's kind of sort of a quasi-deference, right? So they're gonna give the agency respect. And the amount of deference, where on the spectrum of deference it is, is going to vary with the thoroughness evident in the agency's consideration, the validity of its reasoning, and its consistency with earlier pronouncements, and, again, you gotta love the Supreme Court, all those factors which give it the power to persuade, if not control. You know, like, blah, 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 whatever. You know. So what's the court saying here? Well, what it's saying is, the more careful and thorough and attentive the agency is, it makes a thorough, careful consideration of the various factors. It gives reasons to support its decision. It's not constantly changing its policy interpretations, or not constantly changing its policies, and it's what it's doing is pretty persuasive to the court. Well, then the court will be deferential. So this is what's called Skidmore deference. Okay? And again, this is about where the agency's really adopting broad policies or standards. Now, again, this would be nice and easy if we could stop there, but agencies also adopt ambiguous regulations. Okay? Agencies adopt ambiguous regulations. And then they have to interpret their regulations when they start implementing them. Okay? So let's assume for a moment that you have to get a permit from the Fish and Wildlife Service if you are going to annoy prairie dogs when they're mating. Okay? Let's just assume that's don't worry too much about whether that's good law or not. Just assume that's the agency's regulation. Okay? So that's the agency's regulation. Okay? And that is an interpretation of the Endangered Species Act. Then the agency is going to adopt some sort of policy guidance that says, when is it that landowners annoy prairie dogs while they're mating? What kinds of things count? When we talk about mating, when's that actually happen, right? And so, you might think, well, mating, that seems pretty obvious, but there's, think about nothing else, humans, right? There's lots of different steps, right? The prairie dogs go to the bar, and right? They pick the right song or the wrong song in the jukebox, right? You get the idea, right? Okay, so just right. So what we're getting at here is that the agency is adopting a set of interpretations of its own ambiguous regulations, right? And so there has been two cases, Auer and Seminole Rock. Seminole Rock's a really old one, and this is sometimes called Auer deference. This is sometimes called Seminole Rock deference. And so historically, the Supreme Court has said we will defer to the agency's interpretation of its own ambiguous regulations. Just this past term, this came up in a case called Kaiser. Okay? And this Kaiser is not an environmental law case, but nonetheless, the Supreme Court was considering, one of the questions it was considering, right? The questions they asked of the court was whether or not to overrule Auer and Seminole Rock. Okay? And so the court decides Auer is long-standing Supreme Court precedent, and so therefore they're not going to overrule it, but they're going to narrow it. Right? They're going to interpret what Auer means by narrowing it. So the Auer deference is now more what they call cabined. Actually, this is one of the languages, one of the words that's used, cabined, more narrow. Okay? The decision was written by Justice Kagan. Okay? And who provided the key vote that was needed here? Who provided the key vote?
Roberts?
Yes, Chief Justice Roberts. And so now people are saying that Kagan is the Chief Justice whisperer. That she of all the justices understands exactly what it takes to get his vote. Okay, and there's some basis for that, right? Okay, so I mean, and if you actually see where she is on the spectrum, right? She's not regularly voting as far left as Ginsburg and Sotomayor, right? So she's often a lot closer to the chief. Okay, so she understands, and so she comes up with this opinion that says, okay, you get our difference, but only if the agency's regulations are genuinely ambiguous after the courts apply standard canons of construction. So the courts are going to first use standard canons of construction to interpret the agency's own regulation, and then if it's still genuinely ambiguous, and she says all the reasons that we talked about, language is ambiguous, there are circumstances that come up later you didn't anticipate, and you exercised independent judicial inquiry, you will defer to the agency's interpretation only if it's authoritative and official position, not ad hoc, not just a response to litigation, not a surprise to the regulated party. It implicates the agency's substantive expertise, and it is the agency's fair and considered judgment. Okay? So this is new law. This is new. It doesn't overrule our, but it provides us with more information about how this will apply. So, I promise you, if you deal with administrative agencies of any sort certainly at the federal level, in whatever area of practice you do, you're going to be dealing with all of this at some point in your career. Chevron and Auer and Kaiser and so forth, okay? So, some concepts. Agencies get to interpret the statute as silent or ambiguous. Courts defer to congressional judgment to give agencies discretion in how to effectuate Congress's implicit intent as enacted in legislation. Congress implicitly intended agencies should resolve ambiguities and implications, not courts. We need this just in order to get the job done. Okay? Agency expertise is important, but there needs to be some degree of judicial control or review or scrutiny because there can be what's called agency capture. The agency can become too cozy with the interest groups that it's involved with. Okay? So either regulated industry or environmental groups, either way. Okay? Poor legislating by Congress happens, we talked about that. And Congress can end up hiding the major policy and legal choices because they don't want to make a decision. There is a cute video. I will leave it to you to watch. I think it's NYU Law School. They do a little song and dance about the Chevron two-step. Okay, so I'll leave it to you to watch. It's catchy. All right. So there's some more recent Chevron developments going on. So one is that in a couple cases, one is King versus Burwell, which was the Affordable Care Act case, and then also in a case over the Clean Power Plan, Michigan versus EPA, the U.S. Supreme Court has said that there is no Chevron deference when the agency's interpretation is the resolution of a question of deep economic and political significance. So again, this is another way of saying there are certain policy decisions that have to be made by Congress. This is a step zero kind of statement, or I don't know if it's real. I guess it's a rule. Okay, it says step zero. And in particular, in the Clean Power Plan, the EPA had not done any cost-benefit analysis. The Supreme Court says, okay, surely Congress did not intend for the EPA on its own to decide whether all these industries are going to have to incur these big costs to comply with the Clean Power Plan. And so without doing any cost-benefit analysis, without ensuring that the benefits exceed the cost, right? So they said that if Congress chooses to do that, they can do that. But surely Congress did not intend for the agency to make that decision unless the agency actually does cost-benefit analysis. Well, you've read about cost-benefit analysis already. You know what that's about. Now, obviously, that puts some squelch on the Clean Power Plan, and some people like that, some people didn't. But what's interesting is a cute case because the court says Congress does not hide elephants in mouse holes. Okay, so what does that mean? It means you can't take some little tiny language in the statute and turn it into this huge policy decision for the nation, right? The Congress has to be clear about that, okay? And then, but in Thomas's concurrence in Michigan versus EPA, he says Chevron's unconstitutional altogether. It's a separation of powers issue. Okay? And so that's out there. Is Chevron going to be overruled at some point? Auer could have been overruled. That was the issue in Kaiser. And so instead what happened is we keep Auer on life support, but we limit it a lot, right? So that's the implication of Kaiser we just talked about. Gundy, we talked about that the other day. That is where there is some question about the broad authorization for delegation of big power to or substantial amounts of power from Congress to agencies. Is that still going to stand? Are we going to possibly overrule the intelligible principle doctrine? Okay, so that's out there now. And then finally, there's Virginia uranium mining. Okay. Which is a preemption case. Everybody know what preemption is, right? Right, about whether the federal government has preempted state and local regulation. So this is about, this had to do with some waste issues surrounding mining. And as you might imagine, mining is heavily federally regulated. But the law did not preempt, the law on its face did not preempt the particular kind of state regulation happening in the case. And so there was a challenge by a mining company saying, hey, the state cannot regulate our waste in this particular case because it is inherently preempted by Congress, right? So the preemption is the entire field, the entire subject matter, right? Everybody kind of following me on this? And interestingly enough, and I cannot remember the exact combination, but the majority was a mix of liberal and conservative justices, okay? And what they said is that there is no preemption. The state can go ahead and regulate the mining company in this particular case because if Congress wants to preempt, it has to be more explicit. We are not going to, basically read in to the language some sort of preemption. And basically what they're in essence saying is, especially the more conservative justices are saying is, if Congress wants to do something, they got to step up and actually say it. Okay, we're no longer the court's going to fill in all the gaps for Congress. So there's a pattern there. Do you see the pattern? The pattern is a little bit of dissatisfaction with Congress punting on its authority, coming up with this broad language, and then just expecting either the agencies or courts to fill in the gaps. Right? So I don't know, but we'll see where it goes. I think that's a theme or a pattern of where the courts are now. Does that make sense to folks? And when you see all of these they're all very recent. And it seems to be that, if we're going to regulate something, that needs to come from Congress itself in clear, express language. None of this vague stuff where we're going to suddenly discover in it some regulation, okay? And I know, I'm sort of saying this more, painting a broad brush stroke here. There's arguments in favor, there's arguments against. I'm not trying to make any sort of normative statements about this. I'm just trying to tell you, I think this is what the court is in essence saying. Okay? The majority of the court now. Okay? All right. So, actually, let me go back. So, obviously, what this does is something similar to what we talked about when the agency has a discrete decision to make, when the agency has to interpret either an ambiguous statute or its own ambiguous regulatory language. So, and when I say agency, I mean you as the Fish and Wildlife Service administrator person, right? That you're going to have, you need to think about this, then you are going to have to look carefully at the language. Is it ambiguous or not? And then if you engage in an interpretation, it needs to be thoroughly considered and reasoned, right? You need to have support, it needs to be clear, and it has to be based on your expertise. And probably in addition, it needs to not be just a broad policy pronouncement that really goes beyond what the statute itself authorizes. Does that make sense to everybody? So I'm just trying to get you to think, here are these cases, here are these rules. What practically does it mean for you to do your job at the agency? Okay? All right, so let me pause there and see what questions there are. Okay, one of the questions is, can we stop with the law, please? I've reached my maximum potential. And the answer is no. We've got standing and rightness and all sorts of things. So yeah. No? Okay, let's keep going. Fortify yourself before spring break. Okay. Not spring break, Labor Day break. Okay. Standing rightness. Okay. So now we are talking about jurisdictional limits on judicial review. Standing rightness, exhaustion of administrative remedies. Okay? When we are talking about jurisdictional limits, for the most part, we are talking about when the courts do not have the Article III authority to decide the case. It's simply not within the power of the court to decide the case. So what does that mean? When is it that a party to a lawsuit can question or raise the issue of jurisdiction? You have to do it at the trial level? Have to be in their very first document? No. You can be standing before the Supreme Court on your very last appeal with absolutely nothing in the brief whatsoever, and you can raise the issue of jurisdiction. Okay? It is a matter of Article III power. By the way, the Supreme Court can raise it sua sponte. Okay? At any step along the way, any judge that is hearing the case, any party to the case, anybody can raise the issue of jurisdiction. It is never waived. Okay? It's never waived until the whole thing's just done, right? There's some point where, we've gone to the Supreme Court. But anyway, that's the point. So that's something that's relevant. It comes up in practice. Okay? You take over a case from somebody who screwed it up at the trial level, right? And there's a terrible trial decision against you, right? You're going to be like, yeah, we'll never recover. We're wrong on the law. We're wrong on the facts. What are we going to do? And you get a brilliant idea that on appeal, you're going to raise the issue of jurisdiction, and you can absolutely do it, okay? Because it is, again, about the courts self-policing their authority under the Constitution. So, the basic of standing. There is what is called the irreducible constitutional minimum. In order for a party to have standing, to challenge an agency action or bring a lawsuit, the party must have, the plaintiff, I mean, for the plaintiff to do this, the plaintiff must have an injury in fact that is concrete and particularized and actual or imminent, not conjectural or hypothetical. So very specific, concrete injury, in fact, that you can point to, and it must be now or pretty soon, right? Not sometime vaguely in the future. Secondly, there must be causation, that the conduct that you are complaining about in your complaint has to actually cause the injury. And we say that it must be fairly traceable to the challenged action and not the result of independent third-party action that is not before the court. Third, the plaintiff has to prove redressability. That is likely, not merely speculative, that a favorable judicial decision will redress the injury. So whatever you're asking for from the court can issue it, and that it will actually remedy what you're complaining about. Okay? And I want to emphasize here that if you're a plaintiff, and in most of these environmental cases, that means you are an environmental group that is unhappy about a decision the agency has made, you're unhappy about some polluter or some entity causing harm to the environment, you're unhappy about the agency's failure to act, something like that. But in some cases, the plaintiff may be some sort of industry group, some sort of representative of private property rights, developers, chemical companies, whatever. Okay? But whoever the plaintiff is, you have to plead that you have standing. You have to actually do it, and you have to apply this test. In other words, you have to tell the court exactly what your injury in fact is, how it's concrete and particularized, actual or imminent. You have to address causation. You have to address redressability. Okay? So this is not, you don't just sort of generally say, hey, we have standing, and let the other side challenge it. Right? You have to show that that this is a part of how you get into court. This is a piece of it, and you have to show it. Okay? And here is Article 3 that is the basis, and we're not going to spend any time on that. It's just Article 3. Okay, so landmark standing case is Sierra Club versus Morton in 1972. Okay, and so this particular case is the Mineral King case. So it's the Mineral King area in California, right just near Sequoia National Park. And Disney was going to build some sort of massive amusement park resort extravaganza thing. It was going to be. This was going to be the sort of inland California version of Orlando, right? Okay. Some of you might like Orlando, but but just think, plopping Orlando down at the Sequoia National Park, right? Okay, so obviously there were people environmentalists who were unhappy about the idea that this area here, it was going to be turned into a resort and amusement park, and this is what it looks like, right? Kind of a little bit more majestic than Orlando, right? Okay. So, jumping, nothing against Orlando, but all right. So, the challenge, okay? So the National Park Service had issued a special use permit for this resort, which was considered an adjudication. You have your basic federal jurisdiction. Obviously, this involves a federal question, right? It's a federal question. And the APA, there was a complaint that the agency had made an arbitrary and capricious decision, abused its discretion, and issued a decision that was not in accordance with law because it is allowing this beautiful part of the national park to be developed, right? And that's contrary to the statutes governing national park. The case gets thrown out on the issue of standing, okay? And the environmental group said, we love this area, we will be so heartbroken if it's developed, it would be bad for the environment if it's developed, and so forth. And what the Supreme Court says, U.S. Supreme Court says, is, well, that's all fine and good, but no one has expressly pled that they actually use the area that's going to be developed. Actual use of the environment. Not, I like it, I've seen it once, I intend to see it sometime, but that they actually use the area. Okay? So this use requirement became really key. So here's where it says, nowhere in the pleas or affidavits did the club state that its members use Mineral King for any purpose, much less that they use it in any way that would be significantly affected by the proposed action of the respondents. Okay, so that becomes a key component of standing, and so now the environmental groups have to expressly state that they use the area or the resources that they're trying to protect. So, by the way, one of the things that happened, though, is that in Mineral King, the court provided almost sort of like a guide for environmental groups. And so actually, as you probably know, if you just think about it for a second, there is no Disney resort in the Sequoia National Park, right? I mean, nobody's been there, right? There's no, it did not happen. Because then on remand, the Sierra Club amended its complaint to allege that they actually used the area. So they basically said, the Supreme Court is telling us to say A, B, and C, and so now we're going to say A, B, and C, and lo and behold, it passes this test of standing. So this means that environmental interests are protected. So one of the things that's also really interesting about Mineral King is it was unclear whether somebody who was simply saying, I want to protect the environment, could have standing. And the Supreme Court says yes. Yes, if you use the environment. If you're going to be harmed because the environment that you use is now going to be degraded. Okay? But yes, environmental harms are interests that are protected and that you can have standing under Article 3. And like I said, the injuries have to be related to actually using them. There's also, they just sort of developed this whole sort of organizational representation standing. So Sierra Club, okay? So the Sierra Club is not a person. The Sierra Club, though, or any association has standing to sue on behalf of its members when its members would otherwise have standing to sue on their own right. The interest it seeks to protect or germane to the organization's purpose, and neither the claim nor the relief requested requires the participation of individual members in the lawsuits. Okay? Now, having said that, okay, you can imagine Sierra Club, the Earth Justice, Natural Resources Defense Council, Kentucky Waterways Alliance, whoever, right, will bring lawsuits. They will put their name on the pleadings, but what will they also do? What will they also do? Just think strategically. Think like a lawyer. You are a lawyer for one of these environmental groups. What are you going to do when you file your lawsuit? putting your pleadings together, you're going to put your organization's name as the plaintiff and
Put the individuals.
individuals, yes. You're going to have several individuals who are members of your organization sue in their individual name. I mean, we still all part of the same complaint, right? But your plaintiffs are going to be, the I don't know, the Brandeis Hiking Club, Craig Anthony Arnold, Taylor Gore, Jimmy Golden, whatever, right? You see what I'm saying? It's great to start naming individual people. I mean, with their approval, right? I mean, you can't just pick your members out and say, "Oh, by the way, I sued in your name," right? They have to have their authorization. But you want to make sure that you do not run into any problem with your organization having standing. Okay, so you want to make sure there are actual individuals, and every single one of those individuals has to do what?
Have standing.
They have to have standing. So what that means, very specifically, they have to
Use the thing.
use the resources, the land, the environment that you're suing over, right? Right? Does everybody see that?
Mm-hmm.
Okay. So that is key. And so so let's take a look at some pleadings. Okay. So so this is one that is not such a good idea. Okay. There are no individuals named. Okay. This is risky. Okay? You can do it. You can often get by with it, but it is risky. If I were lawyers for these people, I would have about 6 or 8 names, at least 2 per organization, if possible. Okay? In addition to those organizations. Okay? So here we go. Let's see. So here we have, they're talking about this rare wildflower, blah, 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 blah. This is what it is. This is where it is. They can't stand the heat, blah, blah, blah. It doesn't stand a chance against oil and gas drilling and exploration, dirt bikes, off-road vehicles, livestock trampling, blah, blah, blah. And the Fish and Wildlife Service has failed to list this as a endangered species. It's left it as a candidate species. Okay, and so they go on, and I've circled the key point here, right? That says CNE members often explore Graham's penstemon habitat. So explore the habitat in search of this extraordinary flower. CNE members derive great pleasure and satisfaction from viewing this flower in its native habitat. Right? Do you see why every single one of those words is important? Right? Every single one of those words is important. Okay. What they do, the benefits they get that they are now going to lose, right? And the fact that it is in the native habitat. It is an extraordinary flower, etc. Right? You see what you're doing here with how you plead this, okay? And here is another one. And again, these people, I would not file these without some individual names in them. But again, they live and visit and enjoy, well, this is where the butterflies live, and visit and enjoy the southern butterflies habitat regularly, right? Not just once or twice, not just occasionally, but regularly. Down here, they observed and attempted to observe the butterflies, etc. Okay? So that's the kind of thing you want. They have participated in efforts to protect and preserve the habitat essential to the continued survival of the species, etc. Okay, so these are examples of what you will want to have in a complaint. And if you are representing the party that is being sued, you are scouring that complaint carefully to raise, to challenge the standing if this kind of stuff isn't in there. Okay, right? Now, the question is, should you challenge standing? If it is, it'll depend in part on whether there's any reason to question the factual veracity, but generally people don't do that, right? But generally, if the members of the Sierra Club say they go out and view the habitat, you're generally not going to put them on the stand and try to say, well, isn't it true that on April 2nd, you were actually eating an In-N-Out burger rather than viewing the habitat? No, that doesn't happen, right? I mean, if they swear under oath that they actually go out and visit it, what's the likelihood that you're going to be able to prove them wrong? Not very, right? That is not worth your effort. But you are questioning to what extent have they pled that they actually use it, and that use is somehow connected to the harm that they say is going to happen if your agency you represent gets to, if their decision is upheld, or if the industry group or whatever that you represent doesn't get run their livestock in the habitat. Does that make sense to everybody? Yes, sir.
Is there a lower limit to the use, like proving use? I mean, is it just like viewing? Is that acceptable?
Viewing is acceptable, right? But viewing where?
In a natural habitat.
Right, and then right. So that's right. So again, if you're on the other side, you're going to be questioning: did they say very precisely and specifically what it is, where it is, under what circumstances, how often? Right? Is that, you see that? Yeah. But yeah, no. There's no bright line there.
So it is defensible though to just say like I go out and view this for my pleasure,
Right.
seeing nature.
Yep. Now that you're going to get into some other challenges, other problems about whether or not then you're going to what is it that you're challenging, and is there an appropriate remedy, right? So that I mean, they're like, oh well, yeah, your viewing enjoyment might be harmed, but there's no remedy for that because eventually this is, this could be under a bunch of overgrowth and you're not going to see it anyway, right? You see what that kind of thing. There could be some ways in which you still end up not winning, but it's not because you have failed to plead standing. Okay. All right. So causation. Plaintiff must allege that he or she has been or will, in fact, be perceptibly harmed by the challenge agency action. It must be something more than an ingenious academic exercise in the conceivable, not just how you might be harmed by the agency's action. It must be true and capable of proof at trial. So now we get into some of the things where, now we might sort of say, okay, well, yes, you have pled an injury in fact, but you can't prove that the agency's action is causing harm to your viewing pleasure, for example. And the classic case is scrap. Scrap gets mentioned in environmental law a lot because it was a bunch of law students at, I now can't remember whether it's Georgetown or George Washington. Was it in there? Did it say? It doesn't say. But it was one of the big DC law schools. The student group decided to challenge the Interstate Commerce Commission's failure to prepare an environmental impact statement for a rate increase that would discourage the use of recyclable materials, which then in turn would lead to pollution, litter, etc. in the parklands of forest in Washington, D.C., which were used by law students. And their use of the parks would be degraded and harmed by all this litter and pollution that was going to be increased because recyclable materials were going to be fewer because of the ICC rate increase. And the ICC doesn't even exist anymore, okay? But this is what the deal was in '73. And this is what is known as the outer limit of causation. This is the outer limit of causation. The court in this particular case says, yep, this is enough, but barely. This is pretty attenuated, but it's direct, and so less direct and perceptible, but it's enough. There's enough of a causal link here to allow standing. Redressability. So redressability is likely, not merely speculative, that a favorable judicial decision will redress the injury. Okay? So here, what you need to be asking is, what remedies does the court have available to it? If the action has already occurred, okay? If the action has already occurred, the agency went out, was afraid you were going to sue them, and got the bulldozers going out at midnight, and the rare plant is gone now, okay? You're likely going to lose on redressability, okay? Maybe all sorts of other things. The agency actually might be in trouble for violating the Endangered Species Act or something like that. But, right, if there's nothing the court can do, it's not going to help. So one of the key things, this is the point where I'm going to start emphasizing this point over and over again. In environmental law and administrative law generally, the main thing that the courts do is they say, A, the agency didn't follow the right legal standards. And or B, the agency didn't follow the right legal procedures. Okay? So those are the two big, they follow the right standards and consider the right factors, they look at the evidence right, but they didn't follow the right procedures. They didn't have a hearing when they were supposed to, their notice was defective, whatever. Okay? And it could be either or it could be both. So therefore, the agency's decision is flawed. It is arbitrary and capricious, it's an abuse of discretion, it's otherwise not in accordance with the law. Therefore, we will remand it to the agency to redo it, to do it the right way this time. Not, we the court are going to decide the opposite outcome must happen, okay? So if the agency fails to consider the impacts on the endangered plant, okay, it is not going to be the case that the court says, and now X amount of land must be set aside for this plant. That is very rare. Occasionally, we're going to find a few cases where the court says Congress's intent is so clear that we're just going to go ahead and say what the outcome has to be. But in most cases, I mean 99.9% of the cases, the court says the agency didn't apply the right standards or they didn't apply the right process, we're sending it back to them. They have to do it over again. Now sometimes that actually kills the whole thing, right? Mineral King is a perfect example. Okay, that actually never went anywhere else because Disney didn't want to see a long drawn out lawsuit. The agency didn't want to see a long drawn out lawsuit. They just gave up. All right? They just gave up. So that happens. And so that can be an environmental victory, if you want to call it that, right? But because they won, but it does not mean that the agency actually ever issued the alternative decision. It just means that because their initial decision was overturned, everybody just gave up. Okay, the Disney and the National Park Service and so forth, those kind of people. All right, or on the other end of the spectrum, the agency makes essentially the same decision. They essentially decide we're going to plow over this endangered plant, but we've now applied or considered the right legal standards. We followed the right legal process, right? And so if they do that, and it gets challenged again, what's going to happen? Well, if indeed they did consider the right legal standards and the right legal process, the court is not going to say, oh, gee, the plant has to be saved, or the agency, right? No, instead they're going to say they followed the law this time. Does everybody see what so that's what the administrative law nature of environmental law is about. It's that the courts are reviewing whether the agency is following the right law and following the right procedure. It is not that the courts have decided there is some fundamental human right to a clean environment that they are now going to enforce. That there is some basic justice consideration for endangered plants, that it now mandates that the plants have to be protected. right? I mean, there are courts that do that. You have some courts in other nations, but that's exactly what happens. There are substantive principles that they follow. That is not what happens in the United States. It is primarily administrative law in that respect. Okay? So that's so we're not done here. We have Massachusetts versus EPA, right? You don't want to miss that, right? And so forth. So we're going to continue this on Wednesday, but we're also going to then start getting into how's all this changing. So you have that reading about what's going on with changes in the environmental law, evolution.